Hello friends, welcome to Civil Procedure Code and the Limitation Act lectures. In this video, we will study suits of civil nature. The suit is of a civil nature if the principal question relates to the determination of a civil right and its enforcement. The Code of Civil Procedure 1908 is implemented for civil cases and civil courts. The civil courts cannot try any other suits which does not come under civil nature. So, it is mandatory to know which suits are of a civil nature and which are not. Every court has its own jurisdiction and civil courts also have its own jurisdiction. Section 9 of CPC provides courts to try all civil suits unless barred. The courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred. Here, the courts means civil courts, and the civil courts are only competent to try the suits of civil nature only. So, according to Section 9, the civil courts are incompetent to try suit when the suit is not of civil nature and when the cognizance of such suit expressly or impliedly barred. By the words suits expressly barred in the section means the suit barred by any enactment for the time being in force. Thus, matters falling within the exclusive jurisdiction of revenue courts or under the Code of Civil Procedure are expressly barred from the cognizance of a civil court. Similarly, matters dealt with by special tribunals under the relevant statutes, example, by industrial tribunal, election tribunal, revenue tribunal, rent tribunal, cooperative tribunal, income tax tribunal, motor accidents claim tribunal, etc. or by domestic tribunals, example bar council, medical council, etc. are expressly barred from the cognizance of a civil court. There are certain suits which are barred by the court itself, such as Section 11 or res judicata barred the trial of a suit in which the matter or issue of the parties has already been decided by a competent court. Other examples are Section 10, Section 95, Order 2, Rule 2, Order 9, Rule 9, etc. also barred to file fresh suit. And by the words suits impliedly barred in the section means to say that there are certain types of suits which are barred by general principles of law. Similarly, certain suits, though of a civil nature, are barred from the cognizance of a civil court on the grounds of public policy. What are the suits of civil nature has been explained by the explanation 1 and the 2 of this section. We will discuss them in the next slide. According to explanation 1, a suit in which the right to property or to an office is contested is a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of a questions as to religious rites or ceremonies. So, The suits of civil nature, according to this explanation, are suits related to the right to property and suits related whether the right to hold office. It is clear from the explanation that it will not make any difference if, if such right to property or to an office depends entirely on the decision of questions as to religious rites or ceremonies. Explanation 2 says, for the purposes of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation 1 or whether or not such office is attached to a particular place. So it is clear from explanation 2 that it is immaterial whether or not any fees had been attached to an office or such an office was attached to a particular place or not. We will enumerate some examples of suits of civil nature and the suits not of civil nature so we can understand the topic better. Examples of suits of civil nature are suits relating to right to property, rights of worship, suits relating to adoption, easement, marriage, rent, specific relief, etc. Examples of suits not of a civil nature are suits relating to pure religious ceremonies like claiming dakshina by the pujari, etc. Suits involving principally caste questions, suits for upholding mere dignity or honor, suits against expulsion from caste. Important case law Shankar Narayan Poti versus K. Sridevi. In this case, it was held that it is obvious that in all types of civil dispute, civil courts have inherited jurisdiction as per Section 9 of the CPC unless a part of jurisdiction is carved out from such jurisdiction, expressly or by necessary implication by any statutory provision conferred on any other tribunals or authority. So, civil courts have inherited jurisdiction for all the civil dispute unless barred expressly or impliedly by any statutory provision. The next case is Siti Nikam versus Municipal Corporation of Ahmedabad, AIR 2002, Supreme Court 997. It was held that the appropriate forum for resolution of an industrial dispute is the forum constituted under Industrial Disputes Act 1947. The jurisdiction of the civil court is impliedly barred in such cases. So, such cases will not come under civil nature and should not try in civil courts. This is the end of this video. Thank you for watching.